A minority of states are so-called community property states. In these states, property earned or acquired during a marriage is presumed to be community property owned by both spouses. Upon divorce, each spouse is entitled to an equal share of the community. Sometimes a spouse brings separate property into the marriage that was purchased on credit, and the partners use community funds to pay down the debt. In Marriage of More, the California Supreme Court wrestled with the proper method for dividing these assets. Lydie D. Moore purchased a house in her own name, making a down payment and obtaining a loan for the balance of the purchase price. For 7 months, Lydie made monthly payments on the house. 8 months after buying the house, Lydie married David E. Moore. Lydie and David lived in the house during their marriage and made payments on the loan using community funds. 11 years after they married, Lydie and David separated. Lydie continued to live in the house and make payments on the loan, which was still in her name. By this time, the house had substantially increased in value. In dividing the parties' property, the trial court determined that the house was Lydie's separate property, but that the community had an interest in it based on the loan payments made during the marriage with community funds. The trial court calculated the community's interest by comparing the percentage of the total principal paid by community payments with the percentage of total principal paid by Lydie separately. The trial court included only payments that went toward principal and not toward taxes, interest, and insurance in its calculations. The court awarded Lydie approximately 75% and the community approximately 25% of the equity in the house. David appealed to the California Supreme Court, arguing that the community property interest in the house should have been based on the full amount of the payments made during the parties' marriage, including interest, taxes, and insurance.